So the CFTC is continuing its deregulatory push under Acting Chairman Pham. On July 18th, it announced that it was withdrawing its advisory on prime brokerage agreements that was issued in 2023. So this is the letter, very brief, just saying that advisory 2306 is withdrawn. And if we go to 2306, it talks about prime brokerage agreements and derivatives clearing organization regarding swaps. And since this YouTube channel is called A Lawyer in Finance Explains, allow me to explain. So let's say you set up your hedge fund and you just want to focus on trading. You might have a prime broker and they handle a lot of the day-to-day stuff dealing with your fund, and they do all of this. And some of them actually do introduction services, so they'll bring you clients. So let's say that you're a customer, you're a hedge fund, and here's your prime broker, and you don't mind trading through him or her if they have the best price. But if you can find a better price somewhere else on Forex or a swap or anything else, you don't mind trading with other people. Generally, you have to put up capital, collateral at these different brokers. So if you put up money here and here and here and here, that's going to tie up a lot of your capital that you could use to trade. So instead of putting up capital here and here and here and here when you have accounts with different people, generally you sign what's called a give-up agreement with these different people that you want to trade with. And then you can trade with whoever has the best price, but you don't need to put up money with these people because you're going to actually go through your prime broker. So your prime broker has relationships with these people, and because you are using a prime broker and you are trading with these people, if you see a better price through any one of these, you can do a trade. And then with this give-up agreement, they will transfer it to your prime broker. And instead of your swap being with one of these people, it'll be through your prime broker. And then you only have to put up money here. And since this prime broker has all your trades with all these people, not just one, if you're long one here and you're short one here, through portfolio margining, you would have to put up less money here. But if you had money at all these individual brokers, if you're long one here and short one here, you wouldn't get any offset because these are two different people. Why would they give you credit for an offsetting position someplace else? Because your position with them is still at risk. But if you carry all your positions with one broker and through their risk management models, you see that positions offset or hedge others, then you would have to put up less capital. So it makes a lot of sense to trade with whoever gives you the best price and use this give up agreement to go through your prime broker who has all your trades, who can then use portfolio margining, and you can use your capital more efficiently, which gives you a better return overall. So back to the letter. So the Division of Clearing and Risk in 2023 noticed that many swap execution facilities were using brokerage agreements that required them to use a single prime broker. And they basically said, not so fast. If the CEF is using a single prime broker as a centralized credit intermediary, it would be required to register as a DCO, a derivative clearing organization, because in essence, that's what you're doing. You're putting all the derivatives together and you're clearing them. And they didn't say that this would be the case in all circumstances, but they just said the way that it's structured and the way a lot of people are doing it, it would implicate that, and they would need to register as a DCO. And they referred people to the section of the Commodity Exchange Act, which covers this. And if you don't like what the statute says, don't blame the CFTC, blame Congress, because they drafted the statute. And a lot of times, people will complain to the CFTC when something is affecting their business, and they will complain to staff that you don't understand how this business works. And the answer is no, you don't understand how the law works. And if Congress drafts something a certain way, even if it doesn't make sense to you, and even if it doesn't make sense to the CFTC, Congress thought it made sense to them, and those are the rules that you have to play the game by. So because a derivatives clearing organization is something where each party can substitute through novation or otherwise the credit of the DCO for the credit of the parties, then if you're operating a CEF and you're requiring everyone to use the same prime broker, again, which is very common with give up agreements and things like that. The prior advisory warned people that that could be a DCO depending on the facts and circumstances. However, the recent letter issued by Acting Chairman Pham withdraws this. So while the statute still says what it says, apparently going forward, the CFTC and their enforcement division will read it a little more loosely. So there are already some exclusions from the DCO definitions for things that it wasn't intended to cover. And here's one: settlement from a sale of a commodity or transaction in the spot market. So generally, the CFTC does not have jurisdiction over commodities in the spot market, other than with very limited exceptions. So that's why that's carved out. Settlement or netting of cash payments in the interbank system. So when the CFTC was given jurisdiction over swaps, the banks and banking regulators pushed back because they didn't want the CFTC involved in the interbank market. And so there is something called Treasury determination, which exempted many of the kinds of Forex trading from most of the CFTC's rules and regulations. And with regard to DCOs, this would take out Forex trading and settlement from that as well. And this would exclude settlement or novations of obligations or contracts on a bilateral basis without a central counterparty. And that would probably encompass a lot of the bespoke swaps that aren't cleared. But as I said, under a very strict reading of this, the prior commission thought a lot of these arrangements with CEFs and prime brokers might have required the prime broker to register as a derivatives clearing organization, but acting chairman is walking that back. So if you have any questions on this, just leave it below. And I'll be putting out more videos as the CFTC issues more no action or interpretive letters. So like and subscribe so you can see them. So like and subscribe so you can be notified when they do come out.
Here's my favorite part, the disclaimer. I'm a lawyer, but I'm not your lawyer. Anything you see on here is for educational and informational purposes only. If you have a specific question about your specific circumstances, seek your own legal counsel for those questions. Nothing here creates an attorney-client relationship between me and you. I am not your lawyer. Okay, got it? Have a great day, everyone.